Good afternoon, ladies and gentlemen, and welcome to the Planning Advisory and Adjustment Committee for Monday, April 24th. The first item, of course, is land acknowledgement. No, should I do that? As we gather today, I would respectfully acknowledge on behalf of council and the community that the city of Pembroke resides on the unceded traditional territory of the Algonquin. We thank the generations of people who have taken care of this land for thousands of years. It is with this statement that we honor and respect the Algonquins on whose land we reside. I would now call the meeting to order. First item on the agenda is the approval of the agenda as it's been circulated. Any additions or deletions? Seeing none, I would ask a motion to approve the agenda as presented. Councillor Keel, seconded by Marcel Mantha. Comments? None. All in favor? Carried. Approval of the minutes of March 27th, 2023. You received the minutes through the mail. I believe there is one slight adjustment or amendment, maybe correction. Could that be Councillor Keel?
Thank you, Mr. Chair. Number 10, dealing with A-4/2023. I did declare a conflict of interest at the beginning of this matter, and I would suggest that the meetings at the end of number 10 should read that Councillor Keel returned to the table at this time.
Thank you very much. Colleen, any concerns? That's okay?
Yes, we'll amend the minutes.
It's been amended. Any other comments? Seeing none, looking for a motion to approve the minutes as they were amended. Marie-Josée, seconded by Councillor Keel. Comments? All in favor? Carried. At this particular time, we ask members if they have any disclosure of pecuniary interests and general nature thereof. Seeing none, thank you very much. We'll go on to our new business. The first item is an application regarding a minor severance. It's actually a consent to sever, and it comes up into two minor variances, and is of a property on 467 and 469 Elmira Street, property owned by Mr. Morrow. And I believe that Mr. Morrow is online.
Mr. Chairman, no, Mr. Morrow was supposed to be here this evening, but obviously something must have come up, so he's not available.
Okay. Has there been any communication from neighbors or anything regarding this application?
There's been no communication. There's been
okay,
no
we'll
concerns.
ask the planner to present the application.
Apologies, Mr. Chair, for my tardiness and committee.
That happens.
So an application for rezoning in 2020 was approved for this property to allow a semi-detached dwelling to be built with relief being granted for lot area, rear yard setback, front yard setback, lot depth, and driveway width. The property is now zoned R2-14. The applicant is now applying for a severance so that each of the units can be individually sold. The applicant has provided a survey with the severance application, and it has been determined that further relief from the relief approved in 2020 is now required. So the official plan designates the property as residential, and that the official plan states that various types of dwellings permitted in a residential designation shall be of the same types of densities. And the property is mainly in this property is mainly in a residential area with a mix of single, semi, townhouse, and apartment dwellings of comparable size and scale in this area. Therefore, this proposed use would be compatible in the neighborhood and is also compatible with existing densities and heights in the neighborhood. The property is bounded on all sides by existing residential uses. According to the city's assessment maps, there are many existing 33-foot lots in this section of the city. In fact, the original approved underlying plan of subdivision for this land illustrated approximately 59 33-foot lots. There were approximately 100 properties within the circulation list, and 46 or close to half of those properties have a frontage of less than the required amount. There is a pattern of lots with reduced frontages in this area as well. Thus, to establish a lot with a reduced lot frontage and a reduced lot area for a semi-detached would be compatible in the existing neighborhood. The zoning, as I said earlier, is R2-14, and according to the attached plan, the lot frontage, exterior side yard, and interior side yard depth requirements are met. In addition, the dwelling unit size of 721 square feet is exceeded for each of the two dwelling units. The rear yard depth and the driveway width has also been granted relief in 2020. So the areas that will require further relief are as follows. At 467 Elmira Street, there is further relief required from the lot area and lot depth. And for 469 Elmira Street, further relief is required from the lot area, lot depth, and front yard depth. The parking requirements are met. And again, relief was approved in 2020 to allow an 18-foot driveway at each of the units. The proposed severance would allow a semi-detached dwelling house to be sold individually to create two individual dwelling units. A 5% parkland dedication fee would not be required as it was previously paid for with the last set of severances. This application meets the intent of the provincial policy statement, which promotes infill, intensification, and efficient development and land use patterns. So the planning department is recommending the severance and the two minor variances subject to a registered plan of survey. And as a condition of the consent application, the minor variances must be approved for 467 Elmira and 469 Elmira Street.
Thank you very much. Is there anyone present, or did the applicant indicate he would be present via?
No, we did try to get a hold of the applicant today and to no avail, but there were no concerns raised from the surrounding property owners.
Obviously, there's no one in the audience to speak for or against the application. Okay, we'll have the members make their comment. Oh, excuse me, before we do that, the inspector, the chief inspector, building inspector, Mr. McLean, any comments on this application?
No. There's still an open permit on this application, but it's just for an occupancy for each of the two units, Mr. Chair. So I have no concerns or comments at this time.
Okay, thank you very much. Okay, we'll ask members for their comments. We'll begin with Mr. Mantha.
Mr. Chair. The difference is so minor, 0.21 meters, 0.01 meters. You're looking at inches on the request. I see no problems with this at all.
Thank you.
The site is.
Same here. I echo Mr. Mantha's comments.
Councillor Keel.
It would appear that we already have, or that the applicant already has a registered plan. So is the requirement to have a registered plan just a pro forma requirement, or did I miss something in that regard?
Through you, Mr. Chairman, it is something that we require. That's a standard requirement. He has the new reference plan. So we are satisfied that that condition is already satisfied.
We're not asking for a new one.
No.
No legal ramifications with respect to this application.
No.
Councillor Jacquino.
Thank you, Mr. Chair. No issues.
No issues. Thank you very much. Okay, as you already indicated, there's no communication from outside, pro or against. Okay, well, we'll ask for a decision, looking for someone to support the planner's recommendation moved by Councillor Ian Keel, seconded by Marie-Josée Levesque. Comments? All in favor? Opposed? Let the minutes show it was unanimous. Okay, going on to the second application, and this is an application on the property 567 Isabella Street. It is a consent to sever application, and Mr. Jones will be representing the applicant, Mr. Steve Wollenschlager. Okay, I've asked the planner to present her planning report.
Okay, so we received an application for a severance to sever a piece of land from 567 Isabella Street to become a lot addition to 610 Pembroke Street West. The proposed severance would remove a piece of land approximately 1,980 square feet in size from 567 Isabella Street and add it to 610 Pembroke Street West. This proposed lot addition is presently being used as a parking lot for the dental office at 610 Pembroke Street West. The owner of 610 Pembroke Street West wants to legalize the parking lot, which then makes the severance application necessary. The removal of the land from 567 Isabella does not affect this property, meeting the lot frontage, lot area, and lot depth requirements. Further, since the severance is for a lot addition purpose, the 5% parkland dedication fee would not be required. A previous severance was applied for and approved in 2000. However, the land was never transferred within the required 2-year time period, and thus the severance lapse. So the applicant is once again, or this may be a new applicant, I should say, is applying for the same severance. So the official plan designates the dental office as highway commercial, which permits the existing use of a dental office and a parking area. The official plan designation for 567 Isabella is residential, which permits the existing single detached dwelling house. The lot addition portion of land was rezoned in 2000 to be the same commercial zoning as 610 Pembroke Street West. So the portion of land to be merged was rezoned to the same zone, which was a C1-4A zone. So relief was granted from the buffering requirements to allow a buffer of trees to surround the existing parking lot. There is also a chain link fence that separates the parking area from abutting residential properties. The zoning bylaw also requires when there's more than 4 off-street parking spaces, a buffer strip with a minimum width of 3 meters shall be located in the yard that abuts a residential zone. And in 2000, relief was granted from this 3-meter setback, as long as there was a row of trees, hedges, or fence erected around that parking lot. A site plan agreement was entered into in 2000 with 610 Pembroke Street West. And the site plan agreement shows the trees and chain link fence around the parking area. And upon inspection, there were trees and chain link fence in place. When the city's new comprehensive zoning bylaw was completed in 2020, the zoning of the lot addition and the dental office were changed to highway commercial. The property at 567 Isabella is also rezoned in 2000 to an R2-9 zone to address front yard depth, interior side yard, and the concrete step deficiencies. And that bylaw also stated that access to the commercial parking lot should not pass through 567 Isabella Street. So the applicant is proposing to legalize the existing parking lot to become a lot addition to 610 Pembroke Street West. This lot cannot exist on its own and thus must be merged with 610 Pembroke Street West. This application is taking into account existing building stock and areas, as well as providing for a mix of residential and employment areas. Therefore, it would appear this application meets the intent of the provincial policy statement. So the planning department is recommending this lot addition to 610 Pembroke Street West, subject to a registered plan of survey and a legal undertaking from a solicitor stating this consent will become a lot addition to 610 Pembroke Street West.
Thank you very much. I believe that Mr. Jones is here representing the application. We would ask you to comment if you have any.
Hello, can you hear me all right?
Yes.
You can hear me good? Okay. Yeah, so I will provide some comments, and Colleen's already touched on the history, and I'll just sort of recap the history of what finds us in the position that that we're in. So this is a do-over from 2000. The previous owner who owned the 610 Pembroke Street West property, that's the one that the lands are being added onto, the dental office. The previous owner bought the 567 Isabella property in 1999. And then I think just on an ad hoc basis started using it immediately sort of as additional parking to the dental office. Some complaints were made at the time. The city reached out to the owner and said, hey, if that's what your intention is, you're going to have to rezone the property. You're going to have to address that parking area. You just can't start parking vehicles in a residential zone off your dental clinic. The previous owner back in 2000 applied for this lot addition severance. It was approved in 2000. The zoning bylaw took place in 2000. A site plan agreement was signed in 2000. If we wanted to take a trip down memory lane, Mr. Levasseur was on the Committee of Adjustments at that point in time and commented, and Ms. Sorial smiling. She also issued a planning report back in 2000 because the estate trustee of the previous owner was kind enough to give me their complete file. So it made the newspaper. I've got the minutes. Anyways, it was supported at the time, and one would think that would be the end of it. The owner of 610 Pembroke Street West, the current owner who wants the lands added to it, well, I should be talking about the previous owner. When he applied for the severance, even though it's in a letter, the critical thing that was overlooked is you have to actually register a deed to effect the severance. I'm speculating that he received the decision and thought, okay, everything is approved, bylaws been passed, site plan agreements approved, and just went about his business without having the lands surveyed, with no reference plan being done and no deed being registered. Interestingly enough, the 567 Isabella Street property has changed hands 5 times since the year 2000, and the current owner of 610 Pembroke Street West bought the shares of the corporation, but basically took over. The ownership of 610 Pembroke Street West changed hands in 2014. It was only about 2020 that the current owner of 610 Pembroke Street was looking into the possibility of a building permit to erect like a covered shelter in this parking area. And it was pointed out to him, hey, you don't own that parking lot, much to his surprise. That then has prompted this application to sort of make right what everybody thought has been the case for the last 20 plus years. The parking lot's been there, it's been used. It was thought to be part of the dental office by the previous and current owners, at least up till a year or two ago. And I'm presuming by the previous owners of 567 Isabella, they would have bought it and sold it, believing that where the fence was, they owned up to the fence and not past their fence. I see Councillor Keel in the audience and a participant. He would appreciate that a title insurance claim was made. So a title insurance claim was made because we've got a current owner of 610 Pembroke Street saying, hey, when I bought this property, I thought that parking lot was part of it. And lo and behold, it ends up it's not. But anyways, this application is to make right what everybody thought was the case leading up to this point in time from 2000 on. So I don't want to take things for granted, but Mr. Levasseur did support the application in the year 2000, and Ms. Sorial did see no issues with it in the year 2000 and has been expressed now. I can see that there was some debate, some concern by neighbors about, a parking lot expansion, but those concerns were addressed by the site plan, by the no access, from Isabella. I see there was conversation that this isn't a parking lot in the sense of anyone can go and park on it. It's additional parking for the dental office. That seemed to be a significant consideration at the time. But really what we're trying to do, and I think Ms. Sorial said this way, is legalize what's actually been on the ground for the last 22 years. Everybody then owns what they thought they owned.
Thank you very much. Nothing like giving my age away.
Sorry, just applying a little pressure.
Anyways, thank you very much. Appreciate that. Any questions to be addressed to Mr. Jones from members of the committee? Okay, seeing none. Were there any comments from outside or anything?
There were absolutely no
No one
calls,
against
no
it?
letters, nothing.
No one
No
against it?
emails, no.
Oh, okay. And I guess I could ask the building inspector, you have any problem with this process, which seems to be a bit of a
Through you, Mr.
cleaning
Chair,
up?
I have no concerns
Yeah.
with this.
Good. I'll ask the members for their comments, beginning with Councillor Keel.
So my only question to Ms. Sorrell is the legal undertaking from a solicitor. I guess my question is, what is the point of that as far as you're concerned? And my guess is that we want this severance to be basically be a one-time thing, that it be added to the dental office. Of course, once a severance is out there, once a severance, always a severance. So in theory, somebody, whether there's a lot addition or a consolidation at the registry office or not, it could still be taken care of. Now that we have cancellation applications as a possibility since, I guess, last January 1st, I'm wondering why we're not using that as a condition as opposed to what I think is a useless solicitor undertaking.
Well, I guess it's through you, Mr. Chairman. It's been always in the past that we wanted to ensure that this particular lot is not a lot that remains a lot on its own, that it's added on or merged with 610 Pembroke Street West. So that was the wording we've used. I mean, if there's other wording that we can use, we'd be happy to use that. But then we had the undertaking just so that we would know that in the future, if it wasn't merged, we had that agreement that it was supposed to be.
So I guess the issue, of course, is that Mr. Jones, who's a fabulous local real estate lawyer, can certainly merge the two properties. A week later, a different lawyer can be instructed to pull them back apart because the one part of the lot still has a severance and could the very next week be sold off on its own again. So I guess that's where my concern lies is whenever I've seen these for the past 10 years, I've thought, okay, you're telling me to go to the registry office and to consolidate them. But the next day, the property owner could unconsolidate it.
Mr. Keel, okay, is there something that we can add that would satisfy your concern? What condition?
So starting, I think it was last January 1st that municipalities were given the right to actually cancel severances for the first time. So the one thing on the Ontario website, for instance, is a consent granting authority may also issue a certificate. In some situations, the original consent granted for a parcel of land may no longer be wanted or needed. And that once a certificate of cancellation is issued, the parcel would be treated as though the previous consent had not been given. This could mean that the parcel would merge with the neighboring lands, which is what we want. We want a legal merger, not just a registry office on paper consolidation. And it says here that in some cases, the consent granting authority may require the owner to apply as a condition of approval. So basically, we would grant the severance to allow you to transfer the ownership. Then we would cancel the severance so that the two lands would effectively merge.
Now, will that happen automatically? I mean, if we approve this particular application and just let it ride its course?
So once you have a severance, that severance exists for all time. So if somebody 20 years from now bought this land, they could sell that same chunk because we granted a severance in 2023. So once you have so if a neighbor of yours was granted a severance 30 years ago, he could sell you that same severed chunk without having to go through municipal.
So what condition can we add on to the
I
to
guess
the
that they,
planner's
that they
recommendation.
request a certificate of cancellation, which we would then issue after the property has been transferred. Then there would be no more severance for that land.
Okay.
And it would sort of be stuck in time
Okay.
again.
So,
I don't know if Mr. Jones has any thoughts on, yes, it would be an extra step, but legally, I think my footing's pretty good.
Okay. Well, that's what I want to do. We don't want to get caught with this kind of a situation again. So do you understand what?
Through you, Mr. Chair. Yes,
Yeah.
I understand.
So does
what-
that mean that the application will have to come back?
No,
No, okay.
no,
So,
it's just allowing the city, the municipality to cancel the severance. And then that way there's no opportunity then for that severance then, or that piece of land
Yeah.
to be merged back to 567 Isabella or stand on its own, which we don't want because it's landlocked, right? So it can't stand on its own.
so you're comfortable then with the logistics that have to be added here or done?
Yeah, we can come up with some wording and
Yeah.
then we'll, yes, okay,
Okay.
yes.
In the meantime, we can carry on with the recommendation from the planner. Okay, well, I'll ask Maddie José to comment.
Excuse me if I could interject just for a second.
Yes, Mr. Blair. Or
All
Mr.
right.
Jones, I'm sorry.
I understand what Mr. Keel is saying, but in this case, and I'm not exactly sure how the city certificate or, I mean, it used to be that we would get the deed stamped. Now I think there may be a separate certificate issued, but I think that certificate is going to read that this is explicitly a lot addition severance to the 610 parcel. And then I think there's verbiage, although I'm not entirely sure, that the, sections 50 sub whatever of the Planning Act continue to apply to any subsequent transactions, which is you can't sell less than all of what you own without planning consent. So after the lot addition takes place, it will merge and form part of the 610 property. Then the Planning Act provisions would say, I believe, if the certificate reads the way I think it's going to read, that you cannot sell lands less than all of the lands you own without planning consent. And this lot addition severance would be specifically just to add the lands to 610. It doesn't create a separate lot. And then this is relevant as well. The 610 property is not a whole lot on a plan of subdivision where it can be dealt with individually, where you can say, well, I'm going to use the fact that 610 is a whole lot to sell it separate from the remainder piece and then have a trailer piece that I can then convey separately. 610 is not a whole lot. I don't believe there was any planning consent for it. So the Planning Act provisions would say you can't sell 610, part of 610 without selling all of the lands that form part of 610, which after this lot addition severance would include that additional piece. So I think in this particular scenario, you don't need a cancellation certificate because I think by operation of law, 610 cannot be sold separate from the entire parcel. And practically speaking, that's legally speaking. Practically speaking, whoever owns 610 and wants to sell it, who's ever buying 610, it only makes sense they want the parking lot. We haven't gone to this exercise because the parking lot doesn't have value associated with 610. And I'm not saying the practicality should trump any legality. I'm saying the legality in this particular scenario is such that if the severance certificate reads it's as a lot addition to the lands in 610, then they will merge. Planning Act says you can't sell less than all of the lands you own without planning consent for that particular parcel, which wouldn't apply in this case because the lot addition severance certificate was specifically for a lot addition, and you can't sell 610 separate from the lot addition because it's not a whole lot and there was no planning consent. I'm not saying it's not an issue. I'm saying in this particular situation, it isn't an issue.
Yes.
Through
Colleen.
you, Mr. Chairman, and just so that everyone is aware, our certificate of official would indicate that this would be a lot addition to 610. So that would say that on our certificate of official, which they require then to be able to transfer the land to 610.
Mr. Keel, does that satisfy your concern?
I know on the certificate, we could certainly have condition. I think we can do time condition. There's a few conditions that can be put, I think, right into the certificate. So for the time being, I'll accept that as basically we're doing a conditional, not just there's conditions for the severance, but we're doing a conditional severance itself.
I wonder, Colleen and Ian, if the committee decides to approve this, perhaps we could have the city solicitor review this to make sure that everything is okay, that Mr. Keel's concern will not happen or could not happen.
Through you, Mr. Chairman, what we could do is, I feel confident in this particular
Yes.
is severance, but we can look into for the future, like a certificate of cancellation for future severances.
That might be a good educational moment because these are
Mhm.
very new as well.
Yes.
The certificate of cancellations.
Okay, thank you very much. Thank you for your comments. After that debate, Marie-Josée Levesque, anything to,
I have nothing else to ask.
Mr.
or to-
Mantha?
yeah.
Councillor Jack, no?
Thank you, Mr. Chair. So I just want to get this straight in my own noggin, that the severed piece of property is being severed from the property on Isabella Street. Is that correct?
That's happened. Yeah.
Right? It has happened and it'll become part of the Pembroke Street lot for the
16,
dental
yeah.
authority.
That's a.
And it'll be used strictly for additional parking for the dental business.
That's right. And then it'll be merged with the 610,
Okay.
which is the dental
Okay.
business. Yes.
It won't be rented out in any particular way to rent as rental property for
No,
parking?
no, it's like additional parking for the dental office.
Thank you.
Okay. I think that we've heard, that's a good debate. We need that sometimes. Okay, I wonder if we could have a motion. Moved by Councillor Keel,
moved,
seconded by
Mr. Chair.
Councillor Mantha. Further discussion? All in favor? Carried unanimously. Mr. Jones, you will receive a copy of the decision within 15 days. And there is a 20-day appeal period from the date a decision is mailed out to you. We normally ask the planner to kind of elaborate on that about the appeal period.
So there is a 20-day appeal period. However, Bill 23 and the More Homes Built Faster Act now restricts who can appeal for severances and minor variances. So there's the minister can appeal, certain public agencies, and the applicant. So neighbors or adjacent property owners are no longer part of that appeal process. And there's been nobody here this evening, and we've received nothing from other agencies or the minister. So
Looks like it's going to be a fait accompli. And this is one of those decisions that do not go to council. It is, it's finished and we just let it, it's now into the process. Mr. Jones made reference into my involvement with the property way back in 2000. I can say this now. I cannot believe we didn't have anybody against it. That had to be one of the hottest topics that we had presented before us. Because people on Isabella Street, especially one resident, did not want that piece of severance to go. You recall that? That was a heated debate we had at that time. It's interesting that 22 years later, it comes back and it's very little debate. Yeah, thank you very much, Mr. Jones.
Thank you.
Okay, the third item has to do with a property on 471 Blank Street. Applicant is Megan McCrae. It's a minor variance application. I'll ask the planner to present her report, or our planning technician is going to do so.
Thank you, Mr. Chair. The applicant has submitted a site plan to construct a residential addition to her single detached dwelling at 471 Blank Street. She first applied for a permit to demolish a single-story portion of the building with the intent to apply for a separate building permit to reconstruct. Upon the planning department's receipt of and review of the building permit application, it was noted that the reconstruction would enlarge the already demolished former portion of the building, and that said enlargement would increase the existing nonconformity of the exterior side yard setback. The existing structure was originally constructed in 1937. Neither the applicant nor the city has a building location survey on file for the property. Based on the allocation of public utilities, it is estimated that the exterior side yard setback of the building is only 0.31 meters, which is 3.35 meters short of the required 3.66 meters. While this setback deficiency could likely be considered legal nonconforming due to the building construction predating the city's first zoning bylaw that was enacted in 1955. The zoning bylaw does have a provision that states nothing shall prevent the enlargement, reconstruction, renovation, or repair of an existing non-complying building or structure, provided such an enlargement, reconstruction, renovation, or repair does not further increase non-compliance with any applicable provisions. As Ms. McCrae desires to construct a larger addition than the footprint of the demolished portion, and because the proposed enlargement is shown to be in line with the existing non-complying building, it is thereby increasing non-compliance with the exterior side yard setback requirement, and hence relief is being requested. In addition to this relief, existing deficiencies of the building and lot have been added to this application as housekeeping items. This includes minimum lot area, minimum lot frontage, minimum front yard setback, and minimum lot depth. The requested relief can be considered minor in nature due to the relatively small amount of relief required and its low impact in the neighborhood. Prior to the recent demolition work, the total non-complying length of the building was 11 meters. The proposed length of the building, including the proposed addition, is 15.5 meters, which is just an extension of the non-complying portion in the amount of 4.5 meters. This will have minimum impact in the neighborhood because the rear yard setback, which happens to be to the nearest abutting property of the non-conforming wall, is able to be met at 7.62 meters. Said property to the rear of 471 Street, which is 470 Eagle Road, has a large depth of 45.72 meters, 23.3 meters of this being rear yard setback itself. This means that there will be over 30 meters of distance between the proposed addition and the nearest building to the non-compliant. This means that there will be 30 meters of distance between the proposed addition and the nearest building to the non-compliant portion of the addition. Further, the nearest driveway on the abutting property also belongs to 470 road and is located at a greater distance than the aforementioned 30 meters. This means that the proposed addition will not create any sightline issues for neighboring properties. The property is zoned residential type 2 by zoning bylaw. This allows for up to 2 primary dwelling units in various forms. Ms. McCrae intends to maintain the use of the building as a single detached dwelling, which is permitted under the R2 zoning, and hence this doesn't meet the intent of the zoning bylaw. And further, all other zoning bylaw requirements, aside from the housekeeping items of the R2 zone, including interior side yard setback, rear yard setback, minimum dwelling unit size, and parking space requirements are met or exceeded. This application is with residential designation of the city's official plan, as well as with the provincial policy statement 2020. Therefore, the planning department is recommending that we approve this application for 471 Pembroke Street to grant relief from minimum exterior side yard setback requirements along with housekeeping items for a single detached dwelling in a residential type 2 zone.
Thank you very much, Owen. And nobody's present to speak to the application. Was there an intent of the applicant to be online?
The applicant, it turns out, was unable to make.
Thank you very much. Did you receive, what did you say?
The applicant is unable to be present.
That's fine. Did we have any communication from outside, one way or the other?
No inquiries nor any submissions.
Okay, thank you very much. Mr. McLean, building inspector, any problems with that? With this particular application?
Through you, Mr. Chair, this application, the permit is ready to be issued. This is a really good example of planning, working very hard to get this variance to the meeting in time to speed the actual build up. So I have no concerns with this whatsoever.
Okay, good. Any questions to the building inspector from members of the committee? Okay, asking Mr. Keel for your comments.
I have one question and then I think I have some follow. The other side just like breathed in deeply. So the only actual legal issue is the one side yard setback. The others are just housekeeping items and didn't need to be done. Correct.
Correct.
So then I have an issue with why this even needs to be here because I don't think it should be. The side yard setbacks are basically measured at the closest point. The existing closest point is already 0.31 meters. The closest point after this will be 0.31 meters. And when you read the part of the bylaw that you just said, nothing shall prevent the enlargement, reconstruction, renovation, or repair of an existing non-compliant building or structure, provided such an enlargement, reconstruction, renovation, or repair does not further increase non-compliance. This isn't increasing the non-compliance. The setback is still going to be 0.31. I think the city's argument is that it's extending the length of the non-compliance, but that's not how we measure a setback. We measure a setback from the side to the closest point, and it will remain 0.31. Furthermore, the bylaw specifically talks about enlargement. By putting enlargement in there, there's an expectation that council must have thought that people will be enlarging things, which is exactly what's going on here. So my position on this one is that I don't think this is needed. I don't think the bylaw requires an extension that if the extension of the building moved it to 0.29 meters, that would be a problematic setback. That would be further, that would be increasing the non-compliance. This isn't increasing the non-compliance. Non-compliance is staying the same. It's just getting larger, but nothing shall prevent the enlargement of an existing non-complying building. So I think from my perspective, I don't think we need to vote on this. I think the person should get their money back. And I wouldn't like to see one of these back before council or back before this committee, because I think legally, I think we're misinterpreting the bylaw.
Thank you very much.
Through you, Mr. Chairman. It also says that you can't enlarge a building, that you cannot increase the height, the size, or the depth of the building. And in this case, the size has increased from what it was. So as long as it was considered legal non-conforming at the size that it was, it's now the addition is increasing the size. So that is why we have gone for the relief from the exterior side yard, because the size of the building has increased. The size of the addition has increased. As long as the size, I can't remember the exact wording in the zoning bylaw, but the height, the size, and the dimensions of the building, and it has increased.
Respond.
Well, then, I mean, we're just ignoring this section of the bylaw that says nothing shall prevent the enlargement of an existing non-complying building, so long as the non-compliance isn't increased. And again, I would argue the side setback is not further increasing. The side setback is staying exactly the same, and nothing shall prevent the enlargement of an existing building. So again, I think I don't think this should be here. And furthermore, from a larger perspective, the city of Pembroke also doesn't get to decide necessarily the laws on legal non-conforming. For example, I know there's a number of case laws out there, because I had a case once where, for instance, the municipality said, you know, if the property is not used in the same way after 6 months, it loses its legal non-conforming. And the Ontario Court of Appeal said, you don't get to decide, municipality, when it loses its legal non-conforming. The provincial law has a component that says we recognize legal non-conforming. So, just for us to be careful on that one, just because we say it loses its legal non-conforming doesn't necessarily mean that we have the jurisdictional authority to do that either. But mostly, I would just point members of this committee to nothing shall prevent the enlargement of an existing non-complying building or structure, provided such enlargement does not further increase non-compliance. And in this case, there's no increase to the non-compliance. It's still 0.31 meters.
No, it's okay. We're going to carry on. We appreciate your input and your opinion on this, and it's been duly noted. I'm going to ask other members if they have comments.
Thank you, Mr. Chair. I certainly don't have the legal expertise that Councillor Keel has in his profession, but what sticks out to me is that, there was originally, the building was constructed 1937. Neither the applicant nor the city has a building location survey on file. So for that purpose, being here today, I mean, we have to actually not accentuate, but show where the property actually is. And I mean, whether there was no survey, there was some sort of an agreement. In the old days, you just, it was a handshake, you built from that tree to that one, and that was your property. So I think we have to know exactly what is happening. And I appreciate what you're saying. Should it be here? Should it be here? But I think it should be here because there was no survey. We have no idea where the property actually sits, do we, Ms. Sorio? Has an actual survey been done on the property?
No, we have no form of survey on file.
Okay, that's. Do we, because we haven't got that information, I'm just wondering, do we table this particular application until such time as we do get a survey?
Oh,
Or
well,
it's not required, you're hinting?
we haven't
Grandfather?
had that in the past. We haven't asked for surveys in the past, like, because they provide us with a site plan.
Yeah.
And that's their document that they provided us with. Like, so, it's further increasing the non-compliance as far as I'm concerned, because the building is longer, it's increasing the height, the size, and the volume. So that's how we've interpreted. And we feel that because it's not on the same footprint and it's gone longer, that, that could impact an adjacent property owner, and that they should have the right to have a say in this particular application. And so that's how we assess it.
Okay, well, we've got kind of two opinions here, actually, on 2.5. We'll just carry on with the other members to see if they have further comments.
Well, I appreciate the discussion about the relevance of the application and should it come here or not. But in the interest of the applicant, I'm wondering, like, if there's no opposition by neighbors, and if, aside from how to read and interpret and understand the bylaw is concerned, I would see that as a separate issue. And maybe that's a discussion that should happen at council. Just saying, but
Yeah,
I would like to not add further delays to the application.
Mr. Mantha?
I agree with MJ. I don't see the need. I don't see the need to go any further with what we've got in front of us. I don't think there's a problem.
Yeah, I'm going to give each of the other two members one comment for retort.
Mr. Chair, if the building will be sold, will a survey be required? Will not. Thank you.
Mr. Keel?
I'm prepared to proceed with it. I think we should, and by we, I mean the city, I think we should get a legal explanation about what we mean when we say that something can be enlarged. And should the legal explanation come back to say that this wasn't necessary, well, then I would like to see this applicant be refunded, and that in the future, we're not presumably pushing people to say this is needed. So I think we should let it go so that this applicant can get a move on. But I think we should also understand whether or not this was needed at all as a larger process, as I think MJ was getting
Okay,
at.
that's a good point. Okay, from what I gather, then we will proceed with this particular application as members of the advisory committee. And the planning department will take note of the comments that Mr. Keel has made and pursue that appropriately. Thank you very much. Looking for a motion to approve the application as presented by the
So
planning
move.
department.
So move, Mr. Chair.
Moved by Mr. Keel, seconded by Mr. Mantha. Further comments? All in favor? Carry. Okay, I think that's a way of dealing with that. It's one of these little things that maybe might come back to bite us. And it's the kind of thing we like to avoid. So I'll ask the planner to follow up on that in particular issue. Okay, PAAC education session. Well, this is interesting. Consent is ever when we had an application tonight. And it was output in your hands, Colleen.
So a land severance, as you know, is an authorized separation of a piece of land to form a new lot or a new parcel. It's commonly known as a consent as well. If several severances are intended in the same area, a plan of subdivision may be more appropriate. And so it would be determined at that time whether we go with a plan of subdivision or a severance. When considering a severance application, the committee must evaluate the merits of each proposal, such as does it conform with the official plan and is it compatible with adjacent land? Is it compliant with the city's zoning bylaw? We're looking at the suitability of the land for the proposed purpose, including the size and shape of the lot being created. We're looking at adequacy of a vehicular access, parking. We're looking at water and sewer service availability and the need to protect from potential flooding. And the committee's decision must be consistent with the provincial policy statement. So new developments shall be subject to parkland dedication or cash in lieu as required under Section 42 of the Planning Act. And we're looking at 2%, not exceeding 2% of the land for commercial or industrial purposes, and in all other cases, 5%. So this land or cash in lieu of land is conveyed to the city for parkland or for other public recreational purposes, or if cash is given, it goes into a reserve, and that's used for parkland purposes. If a property owner wishes to apply for a severance, well, then they fill out the application. We notify all the property owners within a 200-foot radius. We place a notice on the property, and we have this public meeting like we had today. And then the committee makes a decision, and then the decision is sent out, and there's a 20-day appeal period. And if there is an appeal, it goes to the Ontario Land Tribunal. Again, it's important to note that with the New Homes Built Faster Act, only the applicant, the minister, or a specified person or public body that has an interest may appeal the decision. So it eliminates the appeal from the residents of the area. And again, while these amendments are proposed to facilitate timely approvals and reduce the number of appeals to be considered by the Ontario Land Tribunal, the result is the diminishment of the democratic process. Eliminating the ability for third-party appeals will result in frustration in the community that feels shut out of the process. The present cost for a severance is $600, but plus HST, and the planning department fees will be increasing in May, and the new fee will be $800 plus HST.
Interesting. I guess that's Mr. Ford's way of getting rid of some red tape. Yeah. Okay, anybody want to comment on the educational presentation? Okay, thank you very much. Past decision updates. Owen, you got any?
Thank you, Mr. Chair. At this committee's last meeting of March 27th, 3 zoning and or official plan amendment applications were heard for 231 Hink Street, 583 River Road, and 1200 Pembroke Street West. City Council approved all 3 as bylaw at their meeting of April 4th. Their final day of appeal is April 25th, after which point those bylaws and amendments will be considered final. 2 minor variance applications, one for 357 McGee Street and one for 187 Hunter Street, were heard. Their final day of appeal was April 17th. They are now considered final.
Any questions? Thank you very much, Owen. Okay, I guess the next meeting is scheduled for Monday, May 29th. Any concerns with that date? 4:30? If not, then that's the way it'll be. Looking for a motion to adjourn. Moved by Councillor Giacono, seconded by Marie-Josée. All in favor? Carried. Thank you very much. All right, interesting.